Thank you for coming out. And good morning. I'm here to listen to wonderful Woodrow Hartzog, who's a professor of law at Boston University School of Law, and is one of the best AI scholars. Very, very privileged. Thank you.
Thank you so much. It's really a pleasure to be here. Many thanks to the LISP. Thanks to Chinmay and Heather, who I saw a minute ago, may not be here now. It really is a pleasure to be here. This talk that I'm going to give is about an article that started off as congressional testimony in the Senate when they were trying to figure out how to regulate artificial intelligence. It was done in collaboration with Neil Richards, Ryan Dury, and Jordan Francis at the Washington University Cordell Institute, and is forthcoming in the Florida Law Review, which is available on SSRN if you're interested in the essay version. We had it and then we lost it. Well, it was working like 3 seconds ago. And now, there we go. Okay, we're good. We're up. I just had to cue it up. All right, so I want to start with my own sort of admission, which is that it's really difficult to know what to think about AI at the outset, right? And the reason why is that we've got lots of different voices talking to us. The techno-optimists tell us that AI is going to be a force for good as it becomes integrated into every aspect of our lives. For some people, all we simply need to do is put up guardrails so society can gain the benefit of artificial intelligence systems while minimizing the harms. And then there are the techno-doomers, which is a kind of a dramatic version of the AI hype machine. And they warn us that AI systems could become so intelligent and so powerful that they're going to wipe out humanity. Though that doesn't seem to stop them from trying to build AI systems as fast as humanly possible. Meanwhile, the more skeptical and even the cautiously optimistic crowds are not worried about AI systems becoming so smart that they take over the world, but rather they're worried that they are too dumb and that they already have. Societal well-being hangs in the balance, and there are rules and frameworks for regulating AI depend upon policymakers' mental models about how they go about wanting to regulate artificial intelligence. And of course, problems abound. Artificial intelligence systems are gluttonous for personal information. Mountains of data, as you likely know at this point, are necessary to train models. Companies use this fact to justify all sorts of data collection, including presumptions that human information is fair game to capture and exploit, particularly if it's publicly accessible. The idea that human information is a free resource to anyone with the means and drives to exploit it is already being reflected in many of our information privacy law frameworks. But it's not just data that artificial intelligence systems are after. Modern AI-driven systems have the capacity to capture our time, our efforts, and dictate what we see and what we can do. Industry's mandate to maximize shareholder value ensures that no human resource, including our thoughts, our relationships, our attention, our labor, and our environment, remain unexploited. Companies will go so far as the most permissive interpretation that the law will allow and beyond. Even when companies voluntarily and virtuously avoid dangerous AI tools, they are consistently undermined by less scrupulous actors. A great example is that Google avoided implementing facial recognition technologies into its services because it feared how dangerous that the tool was, only to have Clearview AI and PIM-Eyes barge ahead like Leroy Jenkins. And so industry as a whole simply does not have the incentive or the ability to leave money on the table for the good of society. This inevitably manifests in subtle but persistent expansions of affordances and deployments until it completely colonizes entire parts of our lives. Brett Frischman and Evan Selinger have called this techno-social engineering creep. And once you learn to recognize it, you see it everywhere. IoT doorbells were first designed to provide a simple video feed of the area right in front of your door. Now they're being outfitted with AI-powered facial recognition and anomaly recognition technologies and have a range of 1.5 miles. It would only take a small percentage of people to adopt these tools at scale to ensure that there was nowhere in public anyone could remain obscure. Smartwatches and earbuds were first designed simply to detect when you'd like to use them. Maybe some of them do something simple like measure your pulse. Now companies offer to monitor your mood and your sleep habits. And from that foothold, they plan to make a move into neurotechnology to monitor your thoughts. Where companies once tracked people's clicks and texts, now they collect data on sound, space, eye movement, heartbeat, brain activity, and more. The technology is already here and the patents have already been filed. In pursuit of AI market expansion, companies will invade every single aspect of our lives. Our places of work are already being optimized by AI tools. Employers use dubious affect recognition technologies to screen out prospective employees who don't have the right facial expressions. Once people are hired, companies increasingly deploy AI to micromanage many aspects of our work, such that as much as the tech is going to allow, including how long we take for bathroom breaks and whether our attention is completely focused on our task. No daydreaming, relaxing, or personal time allowed. AI is being pitched to tools for the exact same kind of optimization, as if students didn't have enough to worry about. Now, multiple cameras spread throughout the room will take attendance, monitor whether students are paying attention, and detect their emotional states, including whether they are bored, distracted, or confused. Faculty are not going to be spared either. AI provides a turnkey tool to retaliate against scholars and teachers who write on controversial topics or step out of line even just a little. In short, organizations can and will deploy AI as a micromanaging misery machine. This isn't some science fiction future. This is happening right now. Our social lives will also be affected as AI companies hawk tools to automatically take attendance at church, correct your tone when you're texting others, and write thank you notes when you can't even be bothered. If there is a camera and a screen, facial recognition technology will be jammed into it. Law enforcement has begun to integrate AI into their work using ChatGPT to fill out police reports. The Pentagon is really excited about incorporating generative AI into their processes for summarizing information, wargaming, and real-time decision-making. Companies are even trying to change our physical infrastructure for walking and driving to accommodate AI tools like delivery robots. AI will also poison our information ecosystems as companies deploy generative tools to scam people at scale. Phenomena like false AI obituary spam and AI slop is just the beginning of flooding the public sphere with fraud that naturally follows when you make information, the generation of plausible information, cheap and easy. What's worse is that new AI models will then scrape, learn from, and be built on top of this information pollution, creating a cycle where a model built on misinformation and fraud keeps eating itself. In short, AI will be an Ouroboros of crap. Organizations deploying AI have overwhelming incentives to deploy sensors and screens into every aspect of our lives to collect and exploit everything they can for profit or power, starting with our data and attention. And right now, the law does very little to stop them. Recognizing the challenges that AI poses to worker welfare, consumer protection, civil rights, and many other societal values, companies, advocates, and reformers have proposed a variety of ways in which AI technologies can be mitigated through the risks of AI technologies can be mitigated through law. Sometimes they propose technical fixes, sometimes they propose adoption of AI ethics, or they advocate for guardrails, which is a very popular approach that it gets thrown out as a way of gaining the benefits of AI without having to worry about the harms. Now, everything that lawmakers are doing just assumes that AI can be leveraged as a force for good. I think that is at best a dubious assumption. And I think that a lot of the problems that we're seeing are lawmakers' approaches to solving things. A really good example, the drumbeat to embrace AI grows louder by the day, even though it's as though we've learned nothing from how the internet or social media played out for us. And the bipartisan roadmap released by the Senate really makes it clear the sort of tools that they're proposing to respond. And I highlighted a sort of few examples. Right now, they're saying, well, what we really need in order to maintain U.S. leadership in artificial intelligence is counteract harmful bias, prioritize standards, and we need transparency and explainability. This is a really common approach to regulating AI that we're going to see a lot. The Trump administration eagerly sort of followed suit. They also said that we have to dominate the AI race. We have to sort of win, which is a common narrative that we see. And they propose things like anti-bias measures and transparency. The Colorado AI Act, which is really one of the first AI rules that we've seen at the state level, which is already being walked back, by the way, also proposes basically a thicket of transparency, anti-bias, and risk management guardrails that functionally can get boiled down to the idea that you have to conduct impact assessments if you're using risky AI systems, that you have to comply with transparency requirements and do incident reporting. Again, transparency, anti-bias, risk management rules. We see a general sort of care to avoid biased or what's called discriminatory decisions in the act as well. The problem with all of this is that they are half measures. While these AI reform proposals are important and they're well-meaning, the most AI existing reform proposals simply will not be enough to bring AI within the rule of law and to direct it to making society better rather than more efficient. They will fail to protect us, but even worse, they will do so while giving us the impression that our rules are working and that lawmakers have done enough. And in this sense, I call these measures, we call these measures in this essay, half measures. And in order to bring AI within the rule of law, just the simple point that I want to try to convince you of today, we argue that lawmakers are going to have to go beyond half measures to ensure that AI systems and the actors that deploy them are worthy of our trust. And so to do that, we propose three things. One, you've got to start with the recognition that AI systems are not neutral. Even these sort of foundational models that are sort of general purpose tools are not neutral. And I'll unpack what I mean by that in a minute. Two, lawmakers have to resist the idea that AI systems are inevitable. And I'll talk a little bit what I mean by that. And three, instead of focusing on transparency or self-regulatory efforts or anti-bias efforts, we need more discussions around bright line rules and frameworks that are aimed at limiting abuses of power, which is a lot of what I think we're seeing with the risks of AI right now. So in the essay, we identify four major half measures. And these four half measures, again, we recognize are necessary. They are simply not sufficient. And the first one, the biggest one, of course, is transparency. At best, we argue that transparency can be only a first step and is not an end of itself. Certainly, AI systems are astonishingly opaque at scale, almost beyond human imagining. A decision concerning ordinary people, as decision-making increasingly relies upon AI systems, we should have the right to know the basis upon which those decisions are being made. People subject to AI decision-making do deserve what Danielle Citron has called technological due process. And it does need to provide meaningful notice and transparency. But the reason we say that transparency is a half measure is because transparency isn't always helpful to people without power. Even if you are aware a system is in use, you might not be able to do much about it. It is critical, therefore, that lawmakers have some level of insight into the design and implementation of these systems, but that they not stop there. Because looking into a system does not necessarily also lead to knowing about it. And it doesn't produce accountability on its own. Transparency has to work in tandem with substantive rules and due process requirements to ensure that people are not stripped of their rights. Second, bias mitigation. AI systems are notoriously and perhaps inevitably biased. A host of scholars have spent decades identifying the ways in which AI systems are biased against marginalized and underrepresented communities, most notably along the familiar lines of race, class, gender, and ability. To mitigate bias, lawmakers and regulators and those in industry call for more care in the development of these AI systems. I agree. AI systems will remain dangerously and possibly fatally flawed so long as they reflect harmful societal discriminatory practices. Bias mitigation is undoubtedly worthy of attention, resources, and regulation. However, while indispensable, by itself, debiasing AI systems risks being a half measure in two ways. First, what constitutes fairness in the context of AI systems is highly contested. It is easy to say that AI systems should not be biased. It is difficult to find consensus on what that means and how to approach that goal. The very choice of the mathematical decision of fairness is a political one, as scholars have recognized. Lawmakers must make that difficult decision and give the concept of fairness a clear and firm moral anchor. Second, when lawmakers and industry focus on bias correction, they seem to assume away important threshold questions about whether AI has virtuous goals and uses, whether in particular context or more generally. It is tempting to think that a less biased AI system is less dangerous, but accurate AI systems are, if anything, more dangerous. Less biased AI is more attractive to the powerful who can abuse it. When industry uses bias mitigation to gloss over other imbalanced dynamics of AI, they misrepresent the lessons from these important scholars that teach us that bias is the symptom of a larger problem about how power is amassed and wielded against marginalized communities. To put this point even more simply, even if we were to ensure that AI works equally well for all communities, such an achievement will still create AI systems that can be used to dominate, damage, misinform, manipulate, and discriminate. Do you remember a few years ago when every company came out of the woodwork to hurl their AI ethics principles at everyone? You couldn't walk 3 steps without seeing Microsoft or Google or any company sort of say, here are our ethical principles that we will abide by because we know that AI is new and it's scary and it's dangerous, right? And ethics should certainly be front of mind for companies that design or deploy AI systems. But ethical principles for AI become half measures when these commitments to ethics are commitments in name only, or when they happen after the fact, once these AI tools have been built. Ethics principles operate as a half measure if there's no way to hold companies accountable for failure to align with their espoused commitments, either because their statements are too vague or self-serving in substance, or because ethics boards hold no decision-making or accountability power. And when industry does no more than adopt ethical principles, we get easy to make promises by companies to avoid the practices that aren't in their business model, but silence regarding the dubious tools that can make them money. We also get companies continuing to develop dubious AI systems that violate their own ethical principles, which happens a lot if you go back and track the language of the principles versus the tools that are being made. Professor Ryan Calo at the University of Washington has noted that we are flooded with ethical principles from industry, the government, and even civil society, but this flood has not been accompanied by substantive legal rules. Ethical principles are a poor substitute for laws and can even delay eventual rules, and the skeptic mindedest among us would say maybe that was the purpose of the ethical principles in the first place. Because they can give the illusion of progress, right? We're making progress because we're all sort of coming to a consensus about what we should do. And so in this sense, self-regulatory ethics are a half measure. Now, this one is one that I've been writing about for a while, but one of the most popular approaches to regulate AI, as with things like privacy on social media or the internet in general, has to seek to give people more control or ownership over their data and their creations. We see this in new bills that require consent for data practices or giving people rights over their data. But when legislation becomes too focused on the individual at the expense of society, it can become a half measure for 2 different reasons. First, we are all on the bad end of the most significant power differential in a commercial relationship in human history, as far as I could tell. And then 2, the idea of individual control ignores the idea that we're all in this together and that the wisdom of individual millions and billions of individual self-motivated decisions, like the collective output of that is actually what's best for society. And so it runs into some significant problems. And 30 years of experience with modern privacy law makes one point clear. When it comes to complex technological systems, control over your informational destiny is not only an impossible illusion, but is one that can operate to make consumers do what the technology designers want them to do. And these commitments to control can have the opposite effect than what they are advertised as doing. And I'm happy to get into that more. So maybe at this point, you're saying, all right, smart guy, maybe I'm on board that these are half measures. What should we do to go beyond them? And we've got a few recommendations. Now, it is worth noting that first, we're going to need a functioning administrative state. We're going to need a commitment to rule of law generally, right? So there are a couple of caveats that I unfortunately hate that I have to give right now, which is that if we lose the power to hold corporations accountable generally in our legal structure, then we're toast anyway, right? And so I'm going to sort of put that as clearly a precondition that we don't have to talk about more, but specifically in terms of AI regulation, what are the ways in which we can move forward? First, the first of these is that we need to ensure that we understand that technologies are not neutral. One of the things that we run into a lot in the AI debate is that general purpose tools often are presented as having a kind of neutral valence, right? They can be used for bad or good in the same way that a knife can be used for bad or good. And you wouldn't want to regulate knives, just people using those knives, because knives cut vegetables as well as harm people. I've spent a lot of the past 8 or 9 years of my research trying to argue that there's no such thing as a neutral technology, that every single technology makes a certain reality more or less likely. That's what a technology is. It is a tool meant to act upon society. And so I think that this view of technologies is wrong, right? That it basically provides moral cover for the deployment of tools that have massive effects on society, foreseeable, predictable, massive effects on society under the auspices that it's just a neutral tool that people can use for good and for evil. And so we've got to, I think, move past that. We also have to move past the idea that technologies are inevitable. This is one that I run into a lot, which is that AI is here, it's coming, it's already been established, and you can, shape them maybe a little. You can put up guardrails, but there's sort of no stopping where we are. The metaphor that gets thrown out is that there's toothpaste is already out of the tube. I reject this idea as well, mainly because humans create technologies and we can choose how to guide them however we see. I don't think that any specific technology is inevitable. And I think that the problem is that when you accept the inevitability of these technologies, you speed past the most important question, which is humanity going to be better off with this tool or not overall? And we just go straight to putting up the guardrails, right? And so we miss asking that critical first question. And so as a framing matter, I think we have to move past that. And then the third thing that we have to do in terms of framing and conceptual understanding around AI is we have to avoid the normalization cycle. And what I mean by that is we have to understand that part of the motivation for AI companies to blitz scale us by shoving AI into every nook and cranny of every existing technology that we're already using is to get us to accustom to it or normalize to it as quickly as possible. And so in work with Evan Selinger and Joanna Gunwan, we have argued that technology law too often looks to people's expectations to set the limits of what the rules should be. So, for example, a great example would be a reasonable expectation of privacy is what sets our understanding of what the privacy rules should be. The problem is that over time, people become increasingly acclimated to being watched. People's desensitization to exposure affects how they view reasonable surveillance measures and trade-offs. And so by ignoring lots of small de minimis encroachments that happen slowly but surely over time, we call these nicks, right? Lawmakers, like sort of shaving nicks, lawmakers encourage the normalization of harmful and exploitative AI practices, and there are two processes by which this happens. The first is a psychological process known as unexceptional habituation. And this occurs when people see something as so commonplace that they no longer think about it critically. Do you remember the first time maybe perhaps that you encountered an Amazon Ring doorbell? I remember vividly. I walked up and I saw one. I was like, oh, okay, I guess we're doing cameras on doorbells now. And I thought it was sort of weird, right? And now I see them everywhere all the time, right? And we sort of don't even flinch. I remember the first time they started doing facial recognition at the airport. Does anyone remember this? Has anyone used facial recognition at the airport? Now it is so commonplace that a lot of people have started to even comment on it, right? And where things get really interesting around unexceptional habituation is that the more a tool is deployed, the less remarkable it becomes and it fades into the background. And when this happens, a second psychological phenomenon occurs, which is what's known as favorably disposed normalization. And what this means is that people take their moral cues from the behavior of other people, right? We look at others and say, well, if everybody else is doing it, then I suppose it's okay. And then we sort of internalize that over time in the same way that, like, you've heard the experiments, like if someone starts waiting in line, other people would just start waiting in line. They're like, well, this place must be great. I got to wait in line with these people, even though it leads to nowhere. And so we then come to sort of rationalize our use of AI because everyone else is doing it, right? If it's the first Cranberries album, if everyone else is doing it, why shouldn't we? No Cranberries fans in the audience? Okay. And so maybe you think at this point, you're sort of fomenting a moral panic a little bit, right? Like we've been here before. But I think that there are at least two reasons why it's important to avoid the normalization cycle. One is that by ignoring privacy nicks and the sort of nicks that happen when we allow the encroachment of artificial intelligence to happen, we're sort of creating a de minimis space for autonomy violations and dignitary violations that then just sort of keeps happening over and over. And the yardstick for what we view when we say enough is enough keeps getting drawn back just a little and just a little because we keep getting acclimated, right? We once thought that CCTV cameras were an invasion of privacy, and then we got used to them, right? And we never really have a chance to meaningfully deliberate about whether these cameras or whether these systems are good for society, right? We just sort of get acclimated to it. And then the other problem is that it results in the Collin-Ridge dilemma. And the Collin-Ridge dilemma, for those that study STS, is this dilemma that when a technology is first introduced, the narrative is always, well, you don't want to overregulate this technology because you'll deny society the benefits of it, right? And for those old enough to remember when the internet was young, it was like, oh, the internet's a little baby and it's got a little soft spot on its head, so we don't want to regulate it because we could be the most transformative technology in all of mankind, right? And it got deployed with social media and gets deployed with every technology. But of course, the dilemma is if you allow that and you only regulate when the harms become manifest, by the time those harms become manifest, we've already become acclimated to those technologies and even worse, dependent upon them, right? Uber used this to great effect. We're like, you know what, maybe there are some things about Uber we'd like to change. And like society was just used to being able to whip out a phone and press a button and have a car pull up, right? And so we're not changing that anymore, right? And so that ship has sailed. And so I've heard this referred to as the avocado problem, which is not yet, too late. Right. And so normalization sort of works with that. And so this eventually all will lead us to a disempowerment death spiral where democratic resistance becomes really difficult because the law provides no backstop right now to normalization. Without better rules, the law will allow anything people can be conditioned to tolerate. And because it happens incrementally, we are on track to tolerate everything. Democratic self-governance is simply not possible if people become so powerless and vulnerable that they can no longer conceive of rejecting a tool or a practice. And so then that leads to the final recommendation, which is we need substantive duties and rules to make companies more trustworthy. And this can manifest in lots of different ways. One of the reasons why I think that we need more specific rules is that we sort of have a hesitancy to regulate artificial intelligence also because, has anyone heard the saying, any technology of sufficient complexity is virtually indistinguishable from magic? right? And we feel like we don't understand it and we don't need it. And I think that the law is actually pretty good at drawing bright line rules, and one of the things that we should embrace again. And so we propose the 4 Ds of regulating artificial intelligence, for lack of a better word. There's probably lots more that we could do, but it was relatively catchy. One is the duties, right? More robust duties, not just duties of care, which is popping up a lot with regulating artificial intelligence, but actually duties of loyalty. Duties of loyalty are important and something that I've written out in a lot of my other scholarship, because they are centered on imbalanced power relationships where there's a massive power imbalance and a huge incentive for exploitation. The law is already pretty good at that. It works in fiduciaries. Professor Balkin here is one of the people that has also written at length about this idea. We need a lot more, I think, of that, and I'm happy to sort of talk about what that might look like, but not just duties, but also the design of information tools. And so because every single design choice makes a certain reality more or less likely, we need to get more comfortable regulating that design. We regulate design in all other sorts of areas, right? This is what housing codes are. This is why planes stay in the sky, right? We should do the same for artificial intelligence, thinking about bringing back means to instrumentalities liability, secondary liability, also focusing on the design of structure, or more specifically infrastructure. So there's now a movement afoot. Julie Cohen at Georgetown has started writing about infrastructure and the importance of setting the preconditions for meaningful human flourishing. And that involves sort of taking a step back, looking at corporate governance issues, looking at physical infrastructure. And she actually wrote a really great piece called Infrastructure in the Public Sphere in the Yale Journal of Law and Technology that I would recommend to everyone. And so when I say design, I mean design sort of more broadly and holistically. Another one is defaults, and not just technological defaults, though having some better technological defaults would actually be really helpful. But I also mean legal defaults. So I teach information privacy law at BU, and one of the first things that I teach my students is that unlike in the European Union, in the United States, you can do anything so long as it's not specifically prohibited. In the EU, there's a different rule, which is that you can't do anything processing data unless it's justified, right? We could do better with that here, and we could start with the scraping of personal information. So in an article that I recently just published with Dan Solov called The Great Scrape, we argue that the scraping of personal information for training AI models is anathema to virtually every single privacy principle. And for some reason, we just sort of allow it, right? There was this sort of like weird kind of agreement that we sort of never intervened in on it, but we argue and we propose in the article that the best way to address this is actually to have a presumption against the scraping of personal information for training AI models, unless it is legitimized. And there are ways in which we could legitimize it. Legitimizing it in the public interest would be a great start, and we propose ways in which you could do that. And then finally, and this is what we really want to lean into, we need more dead ends. I have written elsewhere that there are certain AI systems, particularly facial recognition technology, where I do not see any future for humanity where we are better off with this tool than worse off. So the only remedy in such situations is outright prohibitions. Bright line rules, we have seen this happening at the municipal level. We've seen it happening, getting kicked around at the state level. This happens with other systems, right? So bright line prohibitions. I believe Illinois just passed a piece of legislation that said that AI chatbots cannot serve as therapists, right? That there's a sort of bright line prohibition on this. We can talk about the sort of wisdom of that, but we need to start rejecting the inevitability narrative and drawing bright lines about certain systems that we think humanity simply will not be better off with. And so this is the way in which we think that humanity will be better off, by moving beyond half measures. And I appreciate your time and attention and look forward to your questions. Thank you very much.
Hi, I'm Laura. I'm a student here. Thank you for the talk. It's very interesting. I'm sure you've heard of this, but there is at least a community of people who are really concerned about catastrophic risk arising out of AI. Their usual concern is because of the natural progress in AI capabilities that AI would become super intelligent, and then there are all kinds of concerns that are directly out of that. It could become super powerful, it could override human programming. You know what I'm talking about.
Yeah.
My point is that in that framework, maybe the transparency requirements are the most important ones. And in another sense, we're talking about inevitability. That also tickled my brain because it reminded me that the reason why people usually consider inevitability of AGI or intelligence is that we are against a major geopolitical force, China, to reach that level and then like enjoy the benefits of its like explosive potential for economic growth, etc. So there's something there that I was thinking of these 2 points that one, the inevitability argument might be stronger than we can like just prima facie like deny, and also that most importantly it might actually be transparency in the sense that sharing with the federal government gives it then power to stop AI once it's gone a little too far. So I wonder how you would respond to that.
Yeah, so I would, with respect to transparency, I just want to be clear. I'm not saying that transparency is important. It's vital. It's necessary. It's just not sufficient, right? And so what I fear is that the frameworks that we've seen proposed, and once legislation sort of gets enacted, it has a way of being sort of sticky. It feels as though there are transparency requirements and the lawmakers being like, we did a good job on that AI rule, right? And it's not enough. It's just necessary. And with respect to the sort of catastrophic risk, in my, I think, second slide, I called the techno doomers just the sort of flip side of the coin of the AI hype machine. I mean, a lot of it is just a way of saying, oh, our AI is so powerful, you won't believe it. It could destroy humanity even. You should, subscribe to my AI system. And so I think that this is it is fair to, I think, worry about catastrophic risk with any technological system. I think that the world is on fire right now with AI systems, right? And so I think that a lot of the catastrophic risk discussion really is a sort of don't look behind the curtain sort of move for AI systems, for the way in which exploitation and abuse and the sort of slow but inevitable wearing away of critical democratic norms and sort of ability to meaningfully enact power in society is sort of being stripped away from us. And my fear is that by the time any sort of catastrophic risk manifested, the ship will have sailed on democratic self-governance years ago, right? And so I worry about that. And then the other part of your question, remind me again, I'm so sorry.
There's a good inevitability argument because when you put yourself in that framework in which AGI is going to arrive,
yeah,
potential for economic impact is so great, large, amazing that you can.
They say.
They say. And I'm not sure if I believe. But
I mean,
I might believe that you could not step out of the race.
Yeah. So let me say this about what is inevitable, which is that companies are going to inevitably pursue the thing that will be the most profitable. We've seen that time and time again, right? Like, so in that sense, like, I think that narrative is driving a lot of this, which is like this incredible AI potential. OpenAI hasn't even made any money yet, right? I mean, they're taking on billions and billions of dollars of debt, right? Like, I'm not saying this. I think there are lots of people saying this. We're in a massive AI bubble. It's fixing to crash pretty hard. I would imagine that this is going to happen. So I think that the inevitability narrative is over-endowed right now, sort of in society, right? And whether something is inevitable or not, I would just encourage a little more sort of pushback around the narrative that, oh, this is going to happen, this is going to unlock massive efficiencies. It might not. I mean, it could, put everybody out of work. So I saw your hand.
Is there a path, technology, internet, or others that you think provides a guide to regulation and gives you confidence that we'll get it right with AI?
That's such a good question. Sure. So there's a couple of ways in which there's no sort of one legal framework that's going to apply because AI sort of has so many multifaceted risks. It's going to take the entire toolbox, I think, to approach it. But I think that ultimately, the industrial sort of revolution is a really interesting sort of turning point for us that to look back upon as a movement that produced a series of protections that held relatively okay for a long period of time, right? So it gave us the birth of antitrust and competition law. It gave us the birth of consumer protection law. It gave us the sort of tort reform movement that allowed for accountability to products liability really started to sort of kick off, right, in the post-Upton Sinclair days. And so the thing that I suppose I would call us to is the sort of movement to get back in the framing that we did when we sort of woke up from the 1930s and said, things are not great when you sort of let capitalism just run amok, right? And so that would be, rather than a sort of particular tool, a sort of movement would be what I would draw against.
I'm interested in exploring the geopolitical angle a little bit more.
Yeah.
You discussed how corporations have that incentive structure because they're not going to turn down something that makes them more money.
Right.
Is there a possibility that governments face a similar incentive problem in that governments are worried about being outpaced militarily or their GDP growth?
Yeah.
Are ultimately, because of that, never going to take full measures?
Yeah. So I think that's a really great point. And yes, of course, right? I mean, so if democracy works well, then it responds to all sorts of incentives, right? Assuming we're unlocking that. And I would actually say, and this is the number one critique that I've gotten with respect to my call to ban facial recognition, is they say governments are never going to agree to do that because the military wants to use AI and drones for automated strikes because they need more efficiency capabilities. And I do have to sort of concede that it's an uphill democratic argument. I'd actually be happy if we sort of kept a lot of AI military grade, right? So that I mean, there's no reason to say that because something is so dangerous, only the military should use it. Everybody should use it, right? I mean, like that. And so there's a world in which I think we can allow for meaningful governance of AI in the commercial sector and in the employment sector, while allowing sort of military regulation of it to act differently. We have sort of other structures about that. And then the other point, the sort of geopolitical points, and I wasn't the person that made this argument, but it resonated with me when it was made, which is that a lot of these tools are functionally really good at violating human rights, facial recognition being a really great example of that. And I think that the race to sort of violate human rights the fastest is not a race that we should want to win, right? So at a certain point, I think there has to be a sort of value first commitment. Does that?
Yeah, so just going back to the catch-all-first points a little bit, to preface, I was saying it's a little bit silly, but I'd be interested in the extent to which that empirical claim about the world is load-bearing for the kind of regulatory regime that you lay out.
Mm-hmm.
For context, and although I'm a little suspicious, whenever I read I don't know, it was the majority of the Turing Award winners saying they regret their life's work, or whenever I see another person get fired from OpenAI for rating stuff like that.
Yeah.
It just makes me question, whether there actually is a compelling narrative of this is all corporate aggrandizement. And so I'd be particularly interested in a regulatory regime that's robust against that claim being wrong.
Could you say it a little more? I just want to make sure that I understand your question here.
Regulatory regime that you're outlining here,
Yeah,
or is the empirical claim that you were making before about, and most of this doom and gloom is corporate hype.
Oh, right.
Is that necessary? Regime that you're outlining to make sense? Do you think?
Oh, no, I don't think it's load bearing. I mean, I just think that that's a way of sort of processing a lot of the hype, right? But I think that even if there is sort of existential risk related to artificial intelligence, I think that I do think that empirically it is important. Like the empirical claim is that we should worry about what's happening now, not what's going to happen in 30 years is probably true. And I think that, we can debate sort of how close it's this is the Yogi Berra. It's really hard to make predictions, particularly about the future, right? And we've been really wrong about that. One of the things we know about complex systems is that they're virtually impossible to predict, like in advance. But one way of looking at that is that means we should look at the stuff that's happening now rather than stuff that might happen in the future, right? And that's the sort of regulatory framework I would.
So I'm wondering the extent to which the First Amendment is an explainer of why half measures have been adopted. Transparency and disclosure requirements are sustained under the First Amendment. And when you run through your list of your 4 like normative what we ought to do, I'm like, well, a lot of these are going to be cabined in different directions by the First Amendment. So I'm wondering if that means that you think net choice was wrongly decided to the extent that it ruled that a lot of these design choices on the part of platforms are protected speech. And I'm curious why that doesn't make an appearance in the normative argument.
Yeah. So you're right. The First Amendment prohibits. The First Amendment most likely does motivate. Transparency is attractive for at least 2 reasons. One of which is the First Amendment. It seems to be the sort of most. I don't know. I say that. I mean, California got sued for the "Do Not Sell My Information" button, right under the First Amendment, and so there's all sorts. So even that is fraud. The other one is that transparency is like relatively cheap. Like it doesn't disturb the fisc too much. It's like you just say it, and then things will sort of happen. I will say that I think there's a lot of nuance to be had. The reason it sort of doesn't make an appearance is because I think it's a pretty complex discussion about whether algorithms implicate free speech in the same way that, say, the design of user interfaces do, which I think is less actually likely to invoke the same sort of First Amendment scrutiny that algorithmic regulation does. But then things get really interesting when you start talking about regulating chatbots, which is, of course, a speech machine. But to the extent that we still have a rule of negligence in the United States, and to the extent that products liability is going to have any teeth whatsoever, the hill that it may live or die on is maybe artificial intelligence, right? I would argue for a sort of a vision of AI as a series of design decisions unrelated to the expression of the developer that's building them. You never know which way the Supreme Court's going to go on this one. I feel like actually the Supreme Court is kind of split on this issue. On one hand, they're like, super sort of Lochner leaning. And then on the other hand, Clarence Thomas wants to regulate everything, right? And so it's like, I'm not sure. So that's sort of, it's a whole different paper, I guess, is why it doesn't make it. I'm sorry, I saw a lot of hands.
It's good to see you.
It's good to see you.
The prediction of this is imminent and we're going to have catastrophic risk or whatever, is being predicted for the technology has always been, since the get-go, this pretty much the same time frame ahead. A comment and then leading into the question. On the transparency thing, the government does regulate the needs for various kinds of documentation and the requirement for that. And certainly they do that with the DoD.
Yeah.
So maybe you shouldn't call it transparency. I mean, I don't know if that would help, but that was a thought there. But it brings me then to a lot of the work you've done, I've done, your co-authors have done, lots of other people have done on privacy in general.
Yeah.
Asking you 3 problems I see and how you would address. One is the regulatory capture issue.
The regulatory what?
Capture.
Oh, yeah.
Is the way in which having sectoral approaches affects the kinds of things you're talking about. Or maybe you say we shouldn't have sectoral approaches. And one is the tendency that whatever regulation you have, or whatever becomes a ceiling. We just check off compliance boxes, see, we're fine, everything's okay, and therefore we don't have to worry about any of the implications of what we're actually doing.
Right.
So I was curious how you would get at those things.
I suppose I would answer all three by saying I'm a really big fan of the, do you remember, and I just want to keep mindful of the time, how many, do we have 10 minutes left?
Yeah. 2 1:30.
To 1:30? Oh, great. Oh, we're cooking then. Okay, wonderful. I'm sorry. So, okay, good. Well, then I can really properly answer your question. So, do you remember in the early days of COVID, everyone was talking about the Swiss cheese method, right? Like you want to layer this and you want to layer this and you want to this. And if you have enough layers, then you sort of block things. This is sort of how I think about regulatory efforts, right? It's like, no one slice of cheese is gonna sort of keep things from light from shining through. But if you layer enough of them on top, then you're good. In terms of regulatory capture, I will say this. I was going to say this until recently. Consumer protection law, the Federal Trade Commission in general, I think has been as resistant to full industry capture and the reason why is because it's got such a broad mandate. It's hard for one particular industry to fully capture the agency. And so this is why I sort of allude to consumer protection as a really great possible model for regulating some of these AI things. Now, that being said, of course, consumer protection has a massive amount of problems, but I would start with that rather than sort of going narrow, because the more narrow you get, the more, if you get one dominant player in a relatively niche area, then it's relatively easy for them to sort of to capture the agency. And then in terms of the sectoral approach, one of the things I would propose is having a sort of general set of duties or large sort of like there's a if I had a piece of chalk right here. Is this a chalkboard or a screen board? Can I write on this?
Yeah, it's not shocked.
Okay, one time I accidentally drew on that's something that wasn't a chalkboard. So Neil and I made this argument that, well, at least with respect to privacy, there are 4 overlapping circles that are areas where we should focus regulatory effort, right? One of which is data, which is the GDPR, right? So the objective of regulation within the GDPR is data. One of which is, for lack of a better term, we sort of corporate or like structural issues. And so this is kind of corporate governance issues. This is the appointment of a chief privacy officer, right? Like sort of like the sort of structural stuff that is necessary to provide a sort of strong base. One of which is relationships. This is duties of loyalty, duties of trust, duties of confidentiality. You need actually some sort of relation, right, in order to not only justify and actually this goes to First Amendment regulation as well, the question about First Amendment. Relationships are a little more resistant to First Amendment challenges because they're voluntarily entered into. And so it would be really sort of weird to say that fiduciary obligations were violative of the First Amendment. This is Professor Balkett's whole argument. And so that we need to have sort of relational rules. And then we also need to have rules around for battle. This is sort of the catch-all externalities, right? Like there's all these sort of massive, attentional externalities and environmental externalities that come from like AI systems. And so that needs to be part of the conversation as well. And so we need to think about AI as environmental law. We need to think about AI as health law, right? Like there are all these sort of sectors. And so I suppose this is a way of me arguing for a sort of multifaceted, sectoral approach, as well as trying to be as broad as possible. I'm skeptical also of, just politically speaking, we had a few questions about the political process of it all. If you were to have one AI law to rule them all, then tech would have only one target that it had to focus on at a time to water down. And it would pretty effectively, I would imagine, right? But if you've got thousands and hundreds of thousands of small little laws at the state and federal level from the bottom up, I feel a little more sort of optimistic about that approach, not only from a sort of laboratories of democracy perspective, but also from if one falls, there's not a sort of interdependency argument that all of them fall. And so that's my sort of general view of like the best way forward with a lot of this. Did that answer your question?
The third one was floor versus.
Oh, you absolutely should have. You're going to have to agree to some form of preemption if you want anything passed at the federal level. I've always argued for floor preemption, not ceiling preemption. I mean, like the state should be able to go up and above because AI is really complex and a moving target.
They should, but they don't.
But they don't, right? I'm trying to personally, right? There are a group of people sort of trying to change that, right? I mean, I think that some of the states, particularly Vermont, is a state to watch for several reasons, but are looking at trying to sort of go beyond whatever it is we would get at the federal level, not just from a substantive rule perspective, but from an accountability perspective. Like there's just one more sort of law to kick in that you have to be responsible for.
Like to play the devil's advocate.
Sure.
Like that. Okay. I interviewed tech workers who develops AI system, and they have like two interesting points. The first is they say, look, if you raise compliance costs, it takes us, the small players, out of the game.
Mm-hmm.
Well, you are reinforcing the dominant market positions.
Yeah.
Especially developing countries. They have this narrative, the developed countries, they develop the techs without rules, and then when we're catching up, they start to have a lot of rules. I mean, it's always a tricky debate, especially when we're talking about environment rules, for example, but they have a point. The other one is, okay, lawyers are always talking about principles, but we are the people who need to make it operational. So how we do, like really interesting principles. So one example, it's AI regulatory sandbox. Some countries are developing.
Yeah.
So what's your position about it? And last question. One answer for the risk of this debate that our country is becoming far from the others if we start putting some barriers to innovation. One answer to this is global international regulation, like we did with atomic energy and atomic weapons. How feasible is this in nowadays scenario? I mean, it would be nice if the UN system, something like that, but is there any possibility that it happens?
Yeah. I'll start with the last one first because it's the one that I know the least about. I mean, I'm not a sort of international law scholar, and so I don't claim to have a sort of window into the likelihood of global agreement on AI rules. I do think that would be an important piece of this puzzle and not something that I would leave solely to sort of national discretion, given the effect, the incredibly outsized effect that AI is going to have on our lives. I think that we've already seen some discussions like that. And so to the extent that global leaders come to the, whatever sort of convening that there is and say, oh, we just have to, quit all your rules. We need to unleash the global power of innovation. I would say that's the exact opposite way to go, because that's going to sort of only accelerate a lot of the risks that we see and sort of further erode the ability of nations to even govern themselves over time. And so it's unfortunately a vicious circle. To start with your first note about small businesses, if you have too many regulations, then it squeezes out small businesses. It should tell you something that the entities that are the biggest fans of that argument are the mega corporations. They love that argument. They bring it out all the time. Ask Microsoft if they want heavy AI regulation. They'll say, oh, not for us, for the competitors, right? And so on one hand, I think that, it's fair to sort of think about compliance costs as something that is worth weighing when you value regulatory efforts. But on the other hand, I think that to consider that argument properly, you also have to consider the relative risks of whatever it is that you're endeavoring to create. We have this assumption in technology law, and it's an assumption more in the US than in Europe, because again, Europe has the default about data processing, that the creation of data and the creation of AI systems is sort of an amoral act, right, or a sort of neutral act. The idea is that you know, we can create it, and who knows what things we can build. The creation of data itself is a moral act, right? To make information, to distill information down in a shareable, sort of eternally preservable, aggregatable way is a moral act. And every single time we do it, it's a moral act, right? And so the idea that we should sort of analyze this without the sort of further conditioning, like you're engaging in something that affects the lives of billions of people and actually might be, in fact, existential. Maybe we don't want you doing this in your garage, right? Maybe the sort of the myth of the sort of Silicon Valley garage inventor, right? Maybe we want relatively sturdy corporations to do this. And competition law sort of exists for a reason still, right? You can still apply competition law. Maybe this is the failure of competition law. And the idea that the only thing that affects the ability of companies to sort of compete is accountability regulations completely ignores the failure of competition law to do its job over the past, you know, so 100 years. Although there's also an argument that competition law would only sort of break up, even if it was effective, would just encourage lots more competition in a corrupt business model, which is fair. We can talk about that too. But that's how it's going. And then finally, your like, what about the how do we make things implementable, and that's sort of how do we have good rules? Here, I would say I wrote a paper relatively recently and just posted it called "Taking Scale Seriously in Technology Law." And the upshot of the paper was that if lawmakers were to actually get serious about technology law, they would start with the fact that let's consider what this would look like if we scaled it to as far as we think it would go, you know, reasonably. And if you do that, almost the first thing you realize is that you should adopt the precautionary principle because there's no sort of take backs once things get installed. And so I do think that, I mean, you know, regulatory sandboxes are a sort of good example, but the starting rule that I would create with is sort of anything based in the precautionary.
Hi, thank you for being here. I wanted to ask about your writing process. I had the good fortune of happening upon the Great Scrape right when it came on SSRN, like 2 years ago or something.
Yeah.
It was way ahead of its time and very comprehensive and just masterfully done. And so I just love to hear about how you go about doing that.
Thank you very much for the kind words. I appreciate that. So the process starts with for lack of a better word, white hot rage, right? About the sort of, I'm a very anger-driven writer. Even though I'm a very happy person, like I generally speaking, but my writing process is fueled by sort of trying to find a problem. There was an author years ago who said there's sort of two kinds of pieces, and you have to decide which one you're writing, either a puzzle piece or a problem piece. And a puzzle piece is like, how do we get here? Like, what can explain this sort of weird thing? And the Great Scrape, in many ways, is actually a puzzle piece. Like, how do we wind up in a situation where this violates every privacy principle, but we think it's totally fine to do for some reason? But then there's a problem piece, and most of the pieces I write are probably problem pieces, which is like, you know, there's a big problem that the law sort of dropped the ball on, and maybe we should think about a better way to resolve that. And then it involves a lot of reading, so to reading other people, because, you know, we're all sort of standing on the shoulders of giants and trying to think about what's been said already, and then presenting the idea in its early formats, probably at a bar, at a conference somewhere. You sort of soft float the idea, and I've soft floated a lot of ideas, and people are like, "That's the worst idea I've ever heard." You're like, "It is." So, you know, you save those, you put those in a file for elsewhere, and then the ideas that sort of get purchased, you know, late at night at the conference, you know, maybe you do it into an abstract, and then you sort of you sort of keep working it and keep working it, and then the one thing I will say is that you also have to be open to what's the phrase, killing your darlings, you know, like if you sort of get to a point, and I've done this before, we've just been like, this is not the paper I originally thought I was going to write. And so changing it to sort of adapt. And actually, You may have noticed, so we just posted the final version of the Great Scrape online. It changed a lot from the original version. And a lot of it was just because once we really subjected some of those claims to scrutiny, we realized that we maybe could have made it, but it probably would be a stronger, tighter piece without it. So.
I was gonna ask how you manage tone because I mean, in books, you can kind of they kind of want you to come out more on
Right.
one side, but in law review, it's more staid, I guess. So, you start with the white hot rage, and then how do you translate that into a more scholarly tone, and how do you do that without, not doing the anger justice or whatever you want to.
I think so. It's sort of simple, clear writing is the way in which I try to do that. So I try really, really hard when I write an article, and Dan does too. So my co-author on a lot of papers is Dan Soloff, and another one is Neil Richards. And the reason we all tend to sort of write together is we have similar philosophies about writing, which is just like a very clear, sort of direct writing if you're angry, you just sort of have to say why. Right. And so avoiding sort of ad hominem and then sort of saying the reason this is a problem is because, right. And then sort of like putting the justification for that anger, and then hopefully letting it tell the story rather than, having more colorful language in my op-eds or talks.
Many tech companies look at privacy as like a successful form of tech regulation. I was wondering how you think of was privacy successful? What lessons can we take from that?
That's a great question. I'm actually working on a paper on that right now with Dan Soloff, where we make the argument that privacy has largely been unsuccessful on several different fronts. I think that there are some success stories within privacy, but largely speaking, privacy has been watered down through a focus on notice and consent. And the idea that consent, and a lot of it stems from what I would probably say was we got off on the wrong starting point, which is that privacy is about control over personal information, which I think, once you bake that conceptualization of privacy into the regulation, that leads to a series of rules naturally that companies love, because it lets them sort of keep doing what they want, because they can get anyone they want to click the I agree button. And so that focus on individual privacy at the individual level, and at the idea that control is privacy, has neglected a lot of what scholars have called out as the collective problems of privacy. So privacy is not just about you, it's about us for lots of different reasons. One of which is that this is the story of us, right? So you are in this classroom, and so this is your story, but I am giving a talk in this classroom, and so it's my story. And so it's like, how do we sort of then divvy up sort of ownership? But then there are also questions about power, right? And there's a lot of theories in privacy right now about the right way to think about privacy is in terms of just allocations of power and uses of power. And I think on that sense, privacy's failed pretty bad because, you've seen the internet. You've been on social media. We have a lot of rules that even in the law, even sort of on its own terms, we haven't been able to do much about. So the idea that publicly available information is free for the taking has OpenAI and Clearview AI and all the AI companies have relied upon that entirely. That is not something that's is firmly established in law. It actually is a sort of open question, but we've failed on the accountability part to hold companies to that. And now, if you were to take away ChatGPT, people would have a heart attack because we've sort of grown. It's the Coleridge dilemma.
Thanks so much. I was curious to learn a little bit more about the duties of law and care. I've read your work on taking trust seriously, things like that, but I think AI definitely exhibits those fiduciary characteristics, especially for competence. But I think that there is this sense in the industry, both and also for consumers, where when you're speaking to ChatGPT, you're not really expecting them to be trustworthy players and actors. So
all right.
What your response to that would be, and also, do you think that there could be a better argument if we compare these fiduciaries to larger fiduciaries, such as maybe like banks or commercial hospitals? Like, like banks are not fiduciaries per se, I mean, that like, I mean, but in the sense that if you compare money as a commodity and data as a commodity.
Right.
They expect it to be trustworthy to consumers.
And they're highly regulated entities too, right? Based on justifications of the power that they have over, right. That's a great question. Thank you. So generally speaking, so one of the biggest critics, there are several people that critique the sort of idea of privacy as trust, right? Loyalty, care. And one of the biggest ones is like, nobody actually trusts these technology companies. And the argument, which we should then clarify, is we actually don't think that, technically speaking, depending on how you define trust, they do. We define trust as the willingness to make yourself vulnerable to the actions of others. And we do that every time we log on, right? I mean, whether we sort of, we have a fatalistic resignation or not, right? I mean, like that's sort of, we make ourselves vulnerable voluntarily to, and in sort of non-voluntary ways because of our precarity, which only makes us, more vulnerable. But the argument is actually to make companies trustworthy, right? And we need regulation to make companies trustworthy. And the argument there is, what this really about is recognizing that this is one of the most imbalanced and vulnerable human relationships that we have. And this, again, goes back to the sort of First Amendment question and whether, like, how regulable is this and how unique is this? So there is no relationship that we have on Earth that we are more vulnerable to than the relationship that we have with technology companies. And by the way, it's very important to indicate that this is a technology company and not a chatbot, right? So the anthropomorphization of chatbots presents a really unique problem because it hides the moral accountability of the developer of that chatbot, right? So the question about whether AI can be treated as a person is a really good distraction from the question of whether tech companies should be held accountable for the tools that they design and deploy. Right. And so when I'm talking about a relationship, I'm talking about a relationship between the user and the tech company. Right. And so when we all have, we click the I agree button with ChatGPT when you create an account. And there are 5 unique sort of, and let's talk about platforms generally, because all of this, right now AI companies are sort of unique, but it's all going to sort of bleed into platforms, perhaps platform creep, which Chennai can tell you, I think, a lot about. And so let's talk about sort of platforms generally. Think about any relationship in your life and how vulnerable you are, like how exposed you are in that relationship. There is no relationship that is more vulnerable than platforms because of its frequency, right? So you can, we check in with our intimate partner, a couple of times a day, right? While we're at work, and then we probably see them at the end of the day. How many times do you pick up your phone a minute, right? We check with it. We sort of interact with companies all the time, like on a frequent basis. Not only that, we do so completely on their terms, right? We do not get to choose what the choice environment within which we deal with ChatGPT or social media platforms are. They dictate what buttons are available for us. They dictate what we can see, what's available to us. That's not true of our person-to-person relationships, right? They know everything about us. So when we are dealing with other people, we can sort of choose what we reveal and what we don't reveal. But tech companies actually know how long your cursor hovered over the screen, right? Like if eye tracking becomes a thing with the AR, VR glasses, they know what our pupils focus on. If we put the wearables on, they're going to detect follicle. The patents are already filed, right? They can detect whether you get goosebumps about something, right? And so they will know everything about us, like in the most sort of intimate way possible. And not only that, they want to have a relationship with us forever, not discreetly, right? Like I went to the a coffee shop right near Broadway. I can't remember the name of it. Mason Cafe, right. And I go there, every time I come, which is once a year, right, or something like that. Like Google and OpenAI want to be with you until you die, literally. Right, so much so that they have preparations for like post-death account deals, right? And so like this is not an exaggeration, and it's adaptive, right? So in other words, like commercial relationships often are not adaptive, right? Like it's not even personalized. I mean, to say it's personalized is one thing. To say it's personalized and adaptive is another, right? Like based on the fact that I said this word, then I get something in response, right? Or the price changes with surveillance pricing. There is no combination of those elements in any other relationship in our lives that make us that vulnerable, right? And so I think that's a pretty good argument for some robust duties of loyalty, care, and confidentiality. And the way in which Neil and I propose this should break out is, again, the layered metaphor. So the one is the general rule, the catch-all rule, but where the things get really, where the rubber meets the road is the subsidiary duties. And duties of loyalty do this all the time. Great example would be client funds. So when all of you become, or those of you that go on to become attorneys, when you do, you will be under a fiduciary obligation not to commingle your client's funds in your own bank account. It's a violation of loyalty, duty of loyalty, whether they lose money or not. The harm is the sort of betrayal of the relationship itself. And that's a subsidiary rule, right? That follows from a general duty of loyalty. We need more subsidiary rules under loyalty. And there are at least 5 areas that you could imagine subsidiary rules, one of which is data collection. This is the scraping stuff. One of which is data security, right? Data uses, that's one. One of which is confidentiality, right? So like, who do you share information with? That's one. The most interesting one for chatbots is manipulation. To what extent are AI companies allowed to try to persuade you to make a particular choice? And then there's mediation, this is mainly for platforms, which is the way in which the way in which companies create systems for people to interact with each other. Right? And there should be rules about that. And so at least 5 areas for subsidiary rules. And so that's the sort of short pitch for a duty of loyalty.
Hi, thank you so much for this talk. I guess for me, I very much agree with a lot of what you're saying about like AI ethics and AI privacy. But just sort of after working with several, lobbying firms and things and the SST committee, I just struggle seeing the feasibility of like getting them to see the same worldview. So I'm just curious here. I would love for you to speak a bit more about like maybe how to make privacy legislation maybe more palatable. Like, is there a compromise between sort of AI ethics and then also innovation? Because I know that that's, especially in the US-China tech competition, like that's a real like focus. So just any of those questions.
Yeah. So it's such a great question, and it's such a huge issue. Innovation has such a powerful rhetorical force in lobbying, right? So you try to get something passed. I've seen many really good privacy rules be defeated because companies swoop in at the last minute when it passes one chamber of the state legislature and it fails at the other because companies are like, oh, but the innovation, and everyone's like, oh, you're right. We don't want to lose any money, right? So on one hand, one strategy might be focusing on actually having the influence. This is I'm going to make this sort of Larry Lessig move where it's like what really matters is getting money out of politics, right? The outsized ability of corporations, not just corporations, but the leaders of those corporations through dual class stock structure to single-handedly decide the fate of billions of people because they want to make more money, right? Like, so corporate governance is probably a pretty good answer to how do we sort of make legislation more palatable. Well, we fix the preconditions for meaningful democratic representative rules. And so that's part of it, right? And a lot of it is also sort of mixed in with that. It's like at a certain point, there seems to be this idea that we can have it all, like we can make the billions and we won't have to sacrifice anything on human rights, right? Like at a certain point, if we're going to do this sort of democratic sort of governance thing, that we have to make a stand and say, we can do the things that don't violate human rights, right? In the same way that we currently say you can do whatever you want so long as it doesn't wrongfully injure people, right? Wrongfully doesn't harm them. We've made that claim. Companies could make so much more money if they could injure people at will. They used to, right? And then we had this sort of consumer protection revolution. But there's also then this is the less cynical version, right? Maybe to your answer, which is Neil and I, so going back to trust, have tried to make the argument for years that Because companies want to be in this for the long haul, trustworthy companies are really good for long, sustainable relationships, right? Like you can actually make money if you act in trustworthy ways, and people can say, I will trust you with this information, right? I will trust you with my vulnerabilities, chatbot, and presume that you're not going to try to then sell me a thing when I'm emotionally vulnerable, right? Like it looks like you're sad. I've got the answer to all of your sadness if you buy the $9.99 upgrade, right? Or whatever it is, right? Like when you're sort of emotionally vulnerable about those sort of things. And so there is a pitch. And whether it sort of works is another thing, where we can have meaningful commercial thriving relationships with AI as long as the rules are in place. But again, you've got to reduce. You have to encourage companies to think long term about that, and there are a lot of corporate sort of governance and corporate finance incentives that cut really hard against that. So I guess this is my way of saying that corporate governance is a tech law issue.
Thank you. Brilliant as always. Once a year is about as much as I can swing. Otherwise, I would try to do more.
Thank you. Thank you all. I appreciate your great questions. Thank you. And I'm happy to talk afterwards.